Good evening, students. Today I will start with a discussion on a judgment which is important because it raises important discussions in context of a concept in kidnapping. And before we start with that topic, it is important for us to have a simple outline of the sections that are involved in this particular case law. Now, when we look at kidnapping in general, this concept involves actually two categories, and they have been dealt with in a declaratory manner under section 359, where you are told that there are two kinds of kidnapping. One is from India, that is where you are taken out of India, and the other is from kidnapping from lawful guardianship. So let's just have a quick look as to what that concept of kidnapping from lawful guardianship is, because that is relevant to our discussion on the case law. So, kidnapping from lawful guardianship has been defined as something which is taking or enticing of a minor, and that person should be below 16 years of age if they are a male, or under 18 years of age if they are female, or any person of unsound mind out of keeping of the lawful guardian of such minor, or of person of unsound mind without the consent of such guardian, and such person is said to kidnap the minor or person from lawful guardianship. So it gives us basically an outline that if an individual is a minor, and in this situation for males it has been mentioned to be below 16 years, and for females below 18 years of age, and or a person of unsound mind, if such person is taken or enticed without the consent of their lawful guardian, one is said to be committing kidnapping. Another important thing which is pointed out is that it should be from out of keeping of their guardianship. Now, when we look at these terms in short, it is important for us to understand them. Who is a minor has been defined under the provision itself, but some important terms are lawful guardian. Now, this term is also defined in the provision. It states in the explanation lawful guardian is anyone who has an entrustment of that particular minor and is entrusted with care or custody of such minor. So any individual who has been lawfully entrusted, that can be an uncle, a family member, a relative, etc., who has been given entrustment for the care or custody of that individual, of that minor. So one, we have understood who is a lawful guardian. Then we have understood what is critical to kidnapping is that you must take the person or entice the person. As the term take suggests, it is almost an act of forcing the individual. There is this concept of consent, as we can see mentioned in the section, is not complied with. You take the individual or you entice the individual, where you there is this aspect that you are trying to induce the person to come with you by giving some kind of incentive, right? You induce the individual to enter or leave the lawful keeping of your lawful guardian. Now, what is in keeping of your guardian means a situation or a construct where you are considered still to be under the lawful guardianship of this individual. For example, if we say that A has been kept with a relative, from this explanation, it can be said that this individual, if they are entrusted with the care of the minor, is a lawful guardian. As soon as this minor leaves, whether she's taken or enticed by a third party, in that situation, one says that she's taken out of keeping. from the lawful guardianship of such individual. So she is removed from the protection, from the uh, area or this territory where it is presumed that she is under the protection of the lawful guardian, right? So you must prove that the individual, whoever has committed the kidnapping, must be an individual who has taken you away or enticed you, and that has been done out of the lawful keeping of your guardian, right? And there is an exception which is provided, which states that if there is a person who believes in good faith and is the father of an illegitimate child and wants to believe that he has custody of that child, he will not be considered to be committing kidnapping. So, an exception is provided to the provision. In short, this category states that if you take away a minor from the lawful guardian out of his keeping or her keeping, you are committing the act of kidnapping. And there is a highlight of the ages that are provided under which an individual is considered a minor. And at this point, it is relevant to point out, since we have new provisions coming in, the BNS has changed the structure of the kidnapping section. I have highlighted how the sections have been combined and mentioned in section 137 of BNS. This can give you a little bit of an idea of how kidnapping is dealt with under the new law. So you can pause and have a look at the sections which have combined and been introduced in section 137, and also realize that while here we were given ages to distinguish between male and female minors, when it comes to BNS, there is a change and there is simply the mention of the word that whoever takes or entices a child. Age, which was mentioned previously, is not mentioned here. So, because BNS defines children to be those below the age of 18 years, one can say that here child would imply all children below the age of 18 years. So, this change has come in the new provision under the BNS, and that has been highlighted by me here again. Section 2 subsection 3 defines a child, and the term child is mentioned in section 137 when it defines kidnapping. All other elements remain the same, which we visited in this discussion when we looked into section 361 of IPC. Now, in context of our discussion, there are what are we highlighting and what are we discussing is this concept of taking. Are there situations where an individual who is a female and is below 18 still would not be coming under the ambit of being taken because she has committed these things willingly? Right. So, this aspect where a minor female has done an act willingly, one cannot establish that she has been taken and therefore cannot be said that she has been kidnapped. So, this concept of taking an individual out of keeping of a lawful guardian is something which we will now discuss further. The first case that we will deal with is a landmark case, that is S. Varadarajan versus State of Madras. What is the case? The case primarily highlights the fact that there was this girl, Savitri. She was having some interaction with her neighbor. On one occasion, I have highlighted the facts, and these can be seen after pausing the video, that she was seen interacting with her neighbor repeatedly, and it was found that she wanted to marry this individual, and this information was carried by her sister to her father. The father then decides to leave her at a relative's place where she was kept to keep distance from this boy. Now, therefore, the lawful guardian concept has come in, and one can say that this relative, this uncle, is the lawful guardian of this minor girl. Now, what happens is she calls this individual, this boy, and informs where she would like to meet him. And then she does meet him and enters into his car, and subsequently they go to and pick up one individual, Mr. PT Sami, and go towards the registration of the marriage. And the registration of the marriage takes place, and many other aspects have also been mentioned in the fact sheet, which talks about they purchase saris, they purchase jewelry, and so on and so forth. And also the fact that Savitri travels with this individual to multiple places from Satur, Sirukulam, Coimbatore, and then finally they are caught in Tanjore during the investigation of the complaint. This highlights another important fact that if you are an individual, a female minor who has been forced, there have been several opportunities in this situation where you can um, where you have been given a chance to ask for help. You, when you are in court, when you are in a registry office, or when you are in these multiple locations, at these places also there could have been an opportunity for this girl to try and escape or leave or inform any individual that she has been kidnapped, which was not done, right? Also, it has been highlighted that it is not disputed that Savitri was below 18 years of age. She was. But at the same time, one has to understand that while she was below the age of 18 years, she had a lot of maturity to understand between right and wrong. So, good sense did prevail with this individual, right? And the question as to really was she taken when she was the one who made the call, and when had several opportunities to try to inform any individual at so many places that she had been kidnapped, and still she did not do those things. She did not try to tell anyone that she was kidnapped, right? Now, one factor also comes into picture is that was she taken out of lawful guardianship. So in that context the question is answered that first she was in the guardianship of the father and then of the relative, and from there she moves out. So yes, there were lawful guardians involved, but whether she was taken out of lawful guardianship is the relevant question, which cannot be answered, because when we look at this highlighted part, we can see that the aspect of taking is not really complete because she calls and she initiates the discussion, right? If we read through, it says that we have no doubt that though Savitri has been left by S. Natarajan at the house of K. Natarajan, she continued to be in the lawful keeping of the father from the extension of the uncle. And however, the relevant question continues to be that was she taken? She admits that she herself called the appellant to meet her on a certain place of her own accord. So herself had initiated this discussion of leaving her uncle's place. She has also stated that she wanted to marry the appellant, right? And there were several opportunities where she could have actually tried to inform anybody that she was there out of or beyond her will. Another thing that is relevant is that the court highlights that she is at an age where she has this discretion. She is at the verge of attaining majority, and therefore she has some sense as to what is right and wrong. The court says in these circumstances, we find nothing from which an inference can be drawn that the appellant had been guilty of taking away Savitri out of keeping of her father. She willingly accompanied. him, and the law did not cast upon any duty on this individual to take her back to her father. So she went of her own accord, and it cannot be said that this boy had taken her. And there is no duty on this boy to take her back to her father. Right? Because again, the court reiterates that she is on the verge of attaining majority. She is capable of knowing what is good and bad for her. So, this is a decision made on her behalf in context of this particular choice that she is making to live with this boy. It must, however, be understood that taking and allowing a minor to accompany a person is two different things. Taking means you take away an individual, as the word suggests, whereas, on the other hand, this is where a minor has asked, or in our situation particularly, she wants to accompany this male boy to a certain place. So we cannot equate these two as equal. Taking an individual from lawful guardianship is separate, and a minor wanting to accompany you on her own will cannot be considered to be on the same footing, and that is what has been mentioned here, right? That they are two separate things, and in this situation, the latter is applicable, that she wanted to accompany the boy, and she herself actually went away from the protection of the guardianship of her father and uncle, right? And finally, it is also relevant that the court said if we want to make this boy liable, this individual male liable, it is important that we show something of excess which helped her form this intention to go out of the keeping of her guardian. And the court feels that they cannot establish that to the extent which is required for him to be punished for kidnapping. They say that the circumstances of the situation do not provide enough evidence for us to say that he so actively participated to create that intention in the girl. Predominantly, it looks like a situation where she called and she initiated the discussion. So, again, the court has finally said in this part that no doubt the part played by the accused could be regarded as facilitating. He has facilitated the fulfillment of the intention of the girl, but that part in the court's opinion falls short of inducement. It doesn't come to the extent which is required under the section for this boy or this accused to be made punishable under the law, right? So it states that it falls short on inducement to the manner to slip out of the keeping of her lawful guardian, and is therefore not amounting to taking. So finally, to revisit what has been provided for in this case is that there is a girl who is close to attaining majority, and at this time she starts an interaction with the accused, is sent to the uncle's place, from where she calls the accused, meets him at a certain point which she informs, and then on they go to register the marriage, and subsequently multiple places at all points where she is not seen to have been making any kind of voicing any kind of discomfort with the fact that she is with the accused. And the court has therefore said that she is quite old enough to understand right from wrong. She is about to attain majority. And if she has done this of her own accord, and the accused has not contributed as much as is required for it to be shown to be taking, we cannot make him answerable and punishable for the act of kidnapping, because the element of taking is not fulfilled. right? So this case is interesting because the girl is still below the age of 18 years. However, it has been said that because she's old enough to, almost enough to understand right from wrong, and she has taken the step so visibly on her own accord, which she admits. In such situation, one must not make the accused liable, because the required enticement or the inducement on his sense, the active participation required for it to amount to taking, is not there on his behalf. So this is the landmark case in context of this concept, which was relevant for us to discuss before we now go to the new judgment which has been passed. And while the facts are similar, they are not exactly the same. They do transition a bit, and the question comes in this situation, is the concept which was introduced in this landmark case followed? Now, what is the case? The new case, which is Tilak Singh versus State of Uttarakhand, talks about a situation where this accused was living in Fanar and the girl is living in Koti. Now, there are versions to the incident. It is said that the girl was going for an errand to purchase salt, and at that time, the accused, along with father and another third person, came and kidnapped this girl. Another thing which is in debate is that what is the age of the girl? Here, let us say if the girl is X, at one point we see here that it is mentioned that her age is 14 years and 4 months. Okay, while they have been this debate will continue as we go through the case law. Once she's kidnapped per se by these three individuals, it is stated that she is then found subsequently in Dehradun, residing with the accused. And at this point, of course, the arrest takes place of the accused and the girl is taken into custody. There are cases which are levied on the boy in context of rape and kidnapping. When we go further, a debate has come up as to whether he should be punished for kidnapping and rape. During the examination in chief, which took place of this prosecutrix, she establishes that her father was aware and informed that she was kidnapped and had reached out and was trying to make efforts to settle the matter. So there was awareness. They were trying to discuss a settlement out of the situation. It is also clear that she traveled from Dehradun to the village Luni, which is 15 kilometers from Fehnar, where she stayed, in a bus. And in the said bus, they were at the time 15 to 16 people. And she did admit she did not make any effort to raise any alarm while she was traveling in the bus. Now, again, this takes us to the similar situation which was there in the previous case, that you have an opportunity to inform people here when you are in a bus, when you are traveling a considerable distance where there is enough time for you to communicate to other people that you are in a difficult situation. You do not make that effort to inform anybody. She was asked to sign various papers in Dehradun, and that was in courts in Dehradun. Again, giving her an opportunity to respond, to try to communicate that she was in a situation she was not wanting to be in. However, she signs these documents which are relating to marriage and accepts that she was in this public place signing documents, inference being made that you could have communicated that you were in a position of difficulty. And the court says that a perusal of this hints towards the fact that she had gone of her own accord, and also that the defense of the appellant, that he married the prosecutrix, not only that he married her, but also that it was certified in front of a competent authority at Dehradun, and thereafter they were living as husband and wife at Dehradun, creates a defense which is available to this accused. So, what we are trying to establish is that if you are an individual who has been forcefully taken away, you have been in several positions where you could communicate your displeasure, and in fact, you have been also staying as husband and wife subsequently, which hints at the fact that maybe you were okay with the circumstance that you were in. You are accepting of the circumstance and consenting to the circumstance, or as the correct word is, that you went there of your own accord, and that has what been has been identified by the court. Now, the court has also highlighted the past, from the past decision, or the discussion which took place on the context of the case, that she was with this individual for 20 days, traveling from different places with him before reaching the final destination. So, even in the single judge who was dealing with the case previously came to the same conclusion that there was a long span of time which provided for her to communicate that she was in a situation of distress which she did not use. Insofar as the age of the prosecutrix is involved, there have been contradictions. In one facet, it has been told that she is 14 years, and in another, that she is 18 years. And the court has said that where there are two conflicting medical opinions, the one which is in the favor of or for the benefit of the accused is the one that will be perused, or the one that will be given benefit of doubt to. And this is based on this rule of interpretation where there are multiple interpretations coming through. The one which is in favor of the accused is the one that shall be followed through, and which is what has happened here. So now, in context of this female minor, where there were two plausible ages that could have been reached, the court is coming to the conclusion in favor of the accused, giving the benefit to the accused that she was of 18 years. Again, our case, the case of S. Vardarajan versus State of Madras, has been referred here, which we have dealt with. And again, it has been reiterated that the fact of the accompaniment of the individual shows that she was wanting to be the wife of the individual, and that she willingly accompanied him, and the law did not cast upon him the duty of taking her back. She was not a child of tender years and unable to think for herself, and was on the verge of attaining majority and capable of understanding good from bad. So, reiterating the relevant para from the landmark case, the court said that it is clear that the even the high court felt that she was between the age of 16 to 18 years and had the understanding of what was right and wrong, right? And it was also mentioned that she had been voluntarily going with the appellant and traveling towards various places, and then finally residing with him as husband and wife as at Dehradun. So even the High Court had taken this part into consideration and felt that there was willingness on the part of the girl itself. And here the court finally decided that it was through the circumstances, through the evidence that has been brought forth, that it is not this case does not come under the ambit of kidnapping. It is not justified to bring this case under the umbrella of kidnapping because we cannot establish that was she really taken, bearing in mind the fact that she was traveling with him and was also present at courts with him where she signed documents, where she was living with him as husband and wife, they were living together. All these situations hint to the fact that she went of her own accord and was old enough to understand right from wrong. And therefore this context was given that she was actually in the mental elements, having those elements of an adult, and was in a position to decipher right from wrong. And therefore one the context of taking her away from the lawful guardian has been somewhere negated because she knows what she's doing. And these different circumstances which we have discussed highlight the fact that she was doing it with her own will, her own volition. And therefore these charges which were brought upon the individual, this accused, were considered to be not justified by the court, and he was acquitted by the court. So, in short, kidnapping requires an essential element of you taking or enticing. The two situations we dealt with was the first situation where this girl calls up the accused and meets him at a particular point, which she decides, after which they go for registration of the marriage and then multiple places together, subsequently being caught. The court holds the fact that she called him and then at multiple places was with him, and also was in a situation where she admitted that she wanted to marry him. The court said that she was old enough to decide what is right and wrong, and also the fact that she was accompanying and he did not take her and therefore was not liable for kidnapping. A similar situation comes up here. This girl, there is debate on whether she was taken off from her village while she was fulfilling an errand for her home. But subsequently, through the circumstances, one can see that the fact that she went to multiple places, traveled distances, was present at a court where she was signing documents, and did not show that she was there unwillingly, hinted to the fact that she was acting of her own accord, and that benefit must be given to the accused, where you see behavior which has been shown through the circumstances that she was actually not being forced to commit the act. So I hope that this aspect of kidnapping in context of taking an individual has been understood by you. In short, it means that when the concept of taking is involved, you must prove that the individual did something and it was the accused who had the full intention of taking you out of the lawful guardianship of them. And rather, in these situations, one can see in some kind of either contribution of the female minor, or in the second situation one sees that there is a sense of complacency where there is no discomfort seen on the part of the female minor. There a hint towards the fact that she was there of her own accord comes in, and that benefit should be given to the accused. I hope that I was able to make you understand this facet of kidnapping, and I will share the screen once more for in order for you to see the citation of this case, in hopes that you will get a chance to read the judgment. Thank you. Thank you so much.